Good afternoon, everyone. As it's hit 12 o'clock, we're going to kick off. I'm sure attendees will continue to join us. This session, as you know, is about the changes to the public procurement regime in the UK brought about by our exit of the European Union. And my partner, Nick Pimlott, is going to guide us through some of the proposed changes set out in the government's Green Paper, which was published at the end of last year, and sort of the steady state where we are at present. Just some housekeeping. We're hoping that this is quite an informal session, so there is an opportunity to ask questions if you prefer to do that by submitting them on the questions site that's on your screens. Please do that. We will probably finish around 1:30, and then pick up questions then. But if you've got something absolutely pressing that you want Nick to deal with whilst he's heading through, then we can certainly deal with it in that way. I mentioned the Green Paper. You will hopefully all have seen it was embedded in your invitation to today's session, and have had a chance to have a look at it, and I'm sure we'll raise the sort of general temperature on what people thought about the government's proposals. There's plenty to talk about, and Nick, as I say, will guide us through it. Consultation ends on the 10th of March, so there's still time to submit your thoughts. I'm sure you'll have many. So Nick, over to you.
Thank you, Cecily, and welcome everybody. Thanks for joining the session this morning on public procurement in the UK post-Brexit. As Cecily mentioned, I'm going to guide you through that. I'm a partner in our competition and procurement team, work closely with Cecily and many others around the firm, and with both public and private sector clients on procurement matters. Sort of simple agenda. I think I just want to spend a few minutes at the beginning just sort of setting the scene for where we are now, what's the sort of legal regime we have for procurement now, and then perhaps with sort of more sort of interest, what might be changing in the light of the Green Paper. And as Cecily said, please do submit questions in the question box on the right-hand side of your on your webinar page, and either we'll answer them as we go along, or we'll pick them up at the end. As Cecily said, it should be around about half an hour or so of me talking, but then hopefully a bit of time for questions at the end. So where are we now? Well, it won't have escaped your notice that at the end of December 2020, we exited finally from the EU. The immediate impact of that was, of course, that EU law ceased to apply in the UK, and simultaneously with EU law ceasing to apply, a whole raft of other instruments and legislation at both an international and a national level came into effect. So I thought it would be helpful, just because quite a lot of people probably have heard of the Trade and Cooperation Agreement, Boris's deal. If you're involved in procurement, I'm sure you will have heard of the GPA, the Government Procurement Agreement. And then there's the sort of domestic legislation which came into force at the same time. So I'll do a quick canter through that, just so you can sort of see a little bit about how the sort of regime under which the UK is now operating. And if you've looked at the Green Paper itself, you'll see there's repeated references to the UK's accession to the GPA, for example, and other trade agreements. So I thought it'd be helpful just to set the scene before moving into the Green Paper itself. So looking at these in turn, the GPA, what is the GPA? Well, it's an agreement between WTO members. Not all the WTO members, only those who decide to sign up. There are currently 21 parties, comprising 48 WTO members. The EU is a member of the GPA, and all the member states of the EU are, through the EU's membership, also members of the GPA. That explains the difference. The UK used to be a member of the GPA by virtue of its EU membership, but applied to exceed in its own right to the GPA, and that took effect at the end of December. I mean, it's worth noting in passing that the UK's accession to the GPA was not a done deal. It was originally a Theresa May government policy to join the GPA. When the Johnson government took over, there was some doubt as to whether they would continue with that application to join the GPA, but they have done so, and I certainly think, and you can see from the Green Paper if you read it, it does provide a very sort of sound basis in international law for sort of the ongoing application of procurement rules. And what does the GPA do? Well, it requires parties to open up public procurement for economic operators from the signatory states within the scope of the commitments. And like the EU rules, it's built on principles of fairness, impartiality, transparency, and non-discrimination. The UK's commitments, that's to say the sort of the scope which is opened up, basically mirror the EU commitments, which are basically similar to what you see in the EU procurement rules. Save that they cover all goods, but the category of services that covered by the GPA is more limited than the category of services that would have been covered under the EU procurement rules. So for those who remember the days before the Public Contracts Regulations 2015, there was a concept of so-called Part A services, which were services which were opened up to full pan-European competition, included things like computer services, transportation services, and so on. Areas of economic activity which were considered suitable for international competition. So the UK's commitments kind of revert, as it were, under the GPA to that position. Therefore, things like health, education, legal services, social services, and so on fall outside the scope of the UK's commitments. The core principles of the GPA are actually quite similar to the EU procurement rules, but the procedures and the sort of requirements are much simpler, and that's a theme we'll come back to in the when talking about the Green Paper. Another feature of the GPA which differs from the EU rules is there are looser rules on remedies. There's more flexibility for signatories to provide for different types of remedies, and in fact lower levels of remedy than would be applicable under the EU rules. So that's a very important development in procurement post-Brexit, because it really kind of sets the baseline, if you like, for what the UK is obliged to do internationally in terms of procurement. We then have an overlay on top of that of the deal, the UK-EU Trade and Cooperation Agreement, which of course is kind of in the news the whole time because of all the sort of transitional difficulties that are happening as kind of businesses get used to the new trading arrangements with the EU. In relation to procurement, the TCA is, in my view anyway, quite sensible. It simply incorporates the parties' commitments under the GPA. So in other words, it sort of just incorporates it by reference, essentially. It extends the coverage of the GPA. So as between the UK and the EU, coverages are extended to certain sectors, such as hospitality, telecoms, real estate, education, and also to certain utility activities. But importantly, health services are expressly excluded from the TCA. So in relation to health, particularly, not just health, but particularly in relation to health, there is no international obligation either to the EU or under the GPA for UK authorities to open up competitions for health services to international competition. And that's obviously something which the government has made some sort of publicity about. So then moving into the last bit of sort of international agreements, there was the EU-UK Withdrawal Agreement. This is the transition agreement. This is what contains the Northern Ireland Protocol and so on. So just as note that procurements launched before the 1st of January, sorry, that's a typo there, that should be 2021, continue to be subject to the EU rules in full. And I think more significantly, perhaps, frameworks, dynamic purchasing systems, and qualification systems under the utilities regs, which were established before, I've repeated the typo, January 2021, continue to be subject to the full EU rules. So there is a bit of a hangover in relation to existing frameworks, dynamic purchasing systems and qualification systems. And that's probably not going to have a massive practical impact, but there could be some impact in terms of remedies, and especially if the government implements fairly soon some of the changes proposed in the Green Paper. We could find different sets of rules applying to pre-exit frameworks, for example, and then to contracts and frameworks that are launched after that date. Then moving on to the domestic legislation, very important piece of new legislation is the European Union Withdrawal Act. This is the thing which actually implements Brexit, repeals the European Communities Act. It copies EU law into domestic law as at the 31st of December 2020 and creates this notion of retained EU law. From a procurement perspective, importantly, it rebases the regulations that are based on the EU directives, so the public contracts regs, the concession contracts regs, the utilities regs, the defence and security public contracts regs. They were all EU directives. They were all based on EU directives. They were all implemented using powers under this 1972 Act, and so they've been rebased on the basis of the 2018 Act. And the Act also gives ministers quite wide powers to amend law, that EU law that's been retained, or legislation that's been derived from EU law. And as we'll see in a minute, that power has been exercised in quite a light touch way in the procurement context so far. An important aspect for procurement, people involved in procurement, is that it sort of domesticates the case law of the European courts. So, you know, a lot of, almost all of the sort of basic kind of principles of procurement law come from decisions of the European courts ultimately. And if you've been to sort of sessions on procurement law, you will have come across, you know, well-known cases, like, for example, the famous Alcatel case, for example, in relation to debriefing, or, you know, there have been other kind of well-known European cases in the procurement context. All that case law then becomes part of the sort of domestic law. So we haven't lost that. But what can happen is that over time, the courts here can change and refine that. So there will be some incremental change over time through the process of litigation and challenges in the courts. Then lastly, we have the public procurement EU exit regulations, and these are the tidying up rules. These don't change much of substance, but they do remove irrelevant references to European institutions and procedures, and they replace, as I'm sure most of you who are involved in procurement will be aware, they've replaced notification in the official journal of the EU, which is no longer applicable, with notification in the EU notification service is what is referred to, but it's now been branded Find a Tender service. So that's the main practical change. As far as things like notices are concerned, for those of you who've been using it, the form or the content of the notices is basically the same, having removed certain European specific things. So the purpose of these regulations is really just to hold the fort. So we have the kind of the public contracts regs and the other regulations rebased and amended, and there we are. And then the next step, as we'll come on to in a second, is to look at what could be changed. So where are we now? For most UK procurements, I think little immediate change. The main practical change is the use of Find a Tender rather than the OJU. The narrower scope, as I was mentioning, of the GPA and the TCA means that certain contracts in certain sectors wouldn't have to be open to international competition. That's not something I've seen come across my desk yet, but I suspect if anyone on the webinar is involved in the health sector, for example, then that's an area where there will be greater flexibility for UK authorities to, essentially choose domestic suppliers. And an important point is, of course, that UK economic operators, thanks to the GPA, retain access to public procurement markets in the EU and elsewhere. So, in a sense, from looking at it from in the UK outwards, those opportunities are still available, and that's obviously an important part of the government's policy in signing up to the GPA. Okay, so what might be changing? The Green Paper. Cecily mentioned, the Green Paper was published in December last year. Consultation closes on the 10th of March. The proposals are to modernise, simplify and speed up procurement processes, deploying the greater flexibility under the GPA. And I would say that the government is sort of in all sorts of areas losing no time in sort of trying to bank the Brexit dividend in terms of what changes can be made to the law to make them, as they would say, more appropriate for UK circumstances, or at any rate sort of simplify some of the sort of complexities, or in any event reform the law in the light of the new landscape. The Green Paper is, if you've read it, it really does contain a lot of stuff. I mean, it's not just sort of dry technical stuff about changes to procedures. It is about sort of, or at least it purports to be about, sort of almost sort of rethinking what procurement is for, and it kind of talks in terms of lots of the priorities of the government: encouraging growth and productivity, supporting recovery from the pandemic, climate change, focus on social value for money. So things which were, if you like, under the European, I suppose there's a perception that the European procurement rules are very economically focused. I'll talk in a minute about this sort of change to the concept of most advantageous tender from most economically advantageous tender. There's a perception, and to my mind not an entirely accurate one, that the European procurement rules are all about money. It's all about price basically, and they made the EU rules made it difficult for authorities, as it were, to take into account wider priorities, or to use procurement to drive other policy objectives. And I mean, it's certainly the case that, to the extent that the EU rules did inhibit that to some extent, that though some of those inhibitions have been removed. So the Green Paper sort of wants procurement to sort of to do everything, to save the world, to get us out of the pandemic, to generate growth and productivity, which are all great objectives. So that's quite a kind of ambitious, if you like, articulation of what the procurement rules can do. And the sort of core principles which the government is looking at is, first of all, to simplify the existing regulatory framework under a single set of rules. We have at the moment public contracts regulations, utilities contracts, defence and security concession contracts, sort of basically only 4, but they are planning to kind of consolidate that into a single set of rules. I'm a bit of a cynic. I think that when civil servants and legislative drafters try to simplify rules into a single set of rules, they end up making it more complicated, because you still have to have different routes here and there. But I think there is some scope for simplification. They also want to enshrine in law these sort of principles of public good, value for money, transparency, integrity, fair treatment and non-discrimination. I mean, those are in many ways the core of the European rules, but they kind of, I suppose, you add this sort of public good element to it. And contracting authorities will be required to have regard to the sort of national procurement policy statement. So going back to the priorities on the previous slide, these are the things which authorities will have to think about in the procurement context. Although, of course, they have their own priorities and can and must take those into account as well. So it's a sense, I suppose, there's an element here of sort of broadening the scope of what procurement is for. Before coming on to some of the sort of procedural changes, just a note on oversight. The Green Paper kind of majors quite heavily on the idea that procurement practice needs to improve. You know, the commercial capability of contracting authorities could be improved. So the proposal is that a new unit is set up within the Cabinet Office, supported by an independent panel of experts, which will be able to review and intervene to improve the commercial capability of contracting authorities. There has been something in the Cabinet Office. There's a public procurement review system, review service, which has been operating for a few years. I don't think it's had a massive profile or a massive impact, although it has had looked at some interesting cases. It's not there, and this new oversight body won't be there to provide remedies to individual suppliers. It'll be more about, you know, looking at what's gone well and what could have gone better in particular procurements and trying to help contracting authorities improve their commercial capability. So turning to the procedures, as I mentioned earlier, the GPA is much more flexible in terms of the types of procedure. If you're familiar with the EU procurement rules, you'll know we have this sort of multiplicity of different and somewhat overlapping procedures: the open, the restricted, the competitive negotiated, the competitive dialogue, the innovation partnership, and so on, some of which are used more commonly than others. The GPA talks in terms of three procedures, essentially. An open procedure, where effectively you invite bids from the world at large and award to whoever provides the most advantageous tender, subject to certain sort of selection criteria. There's the competitive flexible procedure, as they're calling it, which I think you can equate to the competitive negotiated procedure under the EU procurement rules, whereby effectively you invite bidders, you select a pool with whom you negotiate, and then you have a period of negotiation, invite final tenders, award the contract. And then there's what's called the limited tendering procedure, which would equate to the negotiated procedure without competition. What's Regulation 32 in the public contracts regulations. So that's essentially the single supplier route, called the limited tendering procedure. So the idea is that you bring everything down to these three procedures. You've got one which is a sort of, if you like, a kind of a non-negotiated sort of one-shot type of open procedure. Another one is a competitive flexible, but within that sort of flexible procedure, you could have something which was more like a restricted procedure. So I don't think there's any sort of intent that you should have to have a negotiation or have a negotiation over everything. And those are some of the questions that sometimes come up in the competitive negotiated procedure. In terms of the limited tendering procedure, the single source arrangements, effectively they plan to keep the same criteria that you would have to meet in order to go down the single sourcing route, but with a new crisis ground for the limited tendering procedure. I mean, that's not uncontroversial, because clearly some of the procurement practice that's gone on during the pandemic has come under criticism. You know, the idea that you introduce a new sort of get out from competitive tendering in cases of a sort of another national crisis might be sort of not ideal. So I'm sure there'll be some pushback on that. There are, interestingly, and I'll come on to sort of transparency in a minute, but one of the features of the Green Paper, I think, is that the government is kind of planning to tighten up some of the notice provisions. And in this instance, the plan is to have a mandatory notice and 10-day standstill where there's an award under the limited tendering procedure. And again, for those familiar with the EU-based rules, if you award a contract without competition, you have an option of issuing a so-called voluntary ex-ante transparency notice, a VET notice, setting out your justification for the direct award. So, but that is a voluntary step. The government is effectively proposing to make the VEET notices mandatory in the case of the limited tendering procedure, and in some other instances as well, which I'll come on to. A kind of corollary of this new flexibility is that the proposal is to remove the light touch regime for those services which were covered by the light touch regime, so health, education, legal, and so on and so forth, because there's no need for it anymore. The light touch regime itself was provided for sort of flexibility as to the procedure, so there's no need to have a sort of a more flexible light touch regime, and that seems to make sense to me. And I guess the sort of underlying aim of this new flexibility is the government wants to encourage innovation, innovation in procurement. Maybe that's a good thing, maybe it's not, but the idea is that contracting authorities should be freer to set the procedures that suit them. I've mentioned most advantageous tender. So from meet to MAT, the sort of rather unattractive acronym of meet becomes the slightly less unattractive acronym of MAT. And what does that mean in practice? Well, dropping the economic bit from the most economically advantageous tender. My view, the green paper sort of ties itself in knots a bit on this point. On the one hand, of course, spending public money efficiently is a crucial objective of public procurement. So there has to be an economic element. There has to be a value for money. That has to remain one of the most important criteria. There's some discussion in the green paper about this question of the link to the subject matter of the contract. So the EU rules have very kind of strictly over the years maintained that the criteria for awarding contracts must be linked to the subject matter of the contract. You can't introduce extraneous criteria. And what you see in the green paper is the government really struggling to get around the logic of that position, if you see what I mean. So, it is a very logical position that if you're awarding a contract and you're deciding whether or not who to choose, that you use criteria which are relevant to the subject matter of the contract and not relevant to something else. However, the government thinks in the green paper that it is possible to introduce some kind of exceptions to that, to take account of the priorities that I mentioned earlier, for example, wider societal impacts and so on. So the proposal is that they maintain the link, but they allow for specific exceptions, which are then sort of developed in some guidance. And that'll be a very interesting thing to see how they actually approach that question of exceptions to the logical position of criteria being linked to the subject matter of the contract. And there's also a sort of related to this a proposal to remove the requirement that evaluation must be solely from the contracting authority's point of view, and that links to this idea that procurement could be used for wider societal goods, but nevertheless, it's going to have to be within the frame of these specific exceptions that the government hasn't articulated yet, but proposes to do so in guidance documents. What's happening with selection criteria? This seems to be a bit more sort of tinkering, really. The various proposed changes to the mandatory and discretionary exclusion grounds to sort of bring the mandatory grounds into line with kind of UK criminal law. There's a suggestion that there might create a debarment list, a kind of blacklist of suppliers who are subject to mandatory exclusion. I mean, that is, again, if you've read the green paper, you'll have seen that the government is really sort of tiptoeing around that. It's potentially very difficult to maintain an accurate list of suppliers that are actually sort of prima facie debarred from procurement because they've been involved in, some form of criminal activity which is subject to mandatory exclusion. So it'd be interesting to see whether the government actually pursues that proposal. I think there are real problems with it. There's problems with evidence. There's problems with, damaging people's reputation if they're erroneously on the list and so on. Another area which the reform is proposed, and this is one of the, this was a UK government bugbear that went back to the reform of the public EU rules back in 2013, 2014. The UK government was very keen to bring in the ability for authorities to effectively exclude bidders for poor performance under previous contracts, and they achieved that to some extent in the current EU rules. So the 2015 public contracts regs and the other regs all include some ability for authorities to exclude bidders where there have been poor performance under prior contracts. But it's quite limited, and there has to be an opportunity to self-clean. So there is a proposal to somewhat expand the range of instances in which poor performance can lead to exclusion. Commercial purchasing tools, I've called this section. They're really about dynamic purchasing systems and frameworks. So again, some quite sort of potentially important reforms. Dynamic purchasing systems are kind of essentially open panels. They were supposed to be used under the EU rules for sort of regular or kind of everyday kind of purchases. I don't know if they've been terribly widely used, but the idea is to basically make them more used, replacing both replacing the existing dynamic purchasing system and qualification systems under the utilities rules with effectively a continuously open notice, with a live notice on the find a tender service to allow new suppliers to join with no maximum duration. So essentially a sort of a pre-approved supplier list, but then procurements have to be still conducted from qualifying suppliers using the competitive flexible procedure. So it's not a way around competitively tendering, but it's a way of efficiently, the intention is it's a way of efficiently pre-qualifying bidders. As for framework agreements, which of course are extremely common, the government plans to maintain the existing rules on frameworks, which are closed for up to 4 years. In other words, the rule that a framework can have a duration of up to 4 years before it has to be reopened for tender. But they're also proposing a so-called open framework for up to 8 years, but with an initial period of up to 3 years closed. So a bit more flexibility within the rules on frameworks to allow new suppliers to join at points during the life of the framework, so that the framework doesn't, as it were, restrict that access to that particular set of government contracts for too long, and opens up new opportunities. That's an interesting proposal. I think it's a little bit odd in the way they've expressed it in the green paper in terms of how it might work, because it does seem to be that when you have as it were, an opportunity to enter, everyone has to have an opportunity to enter, including those who are on the framework themselves. So effectively, it seems to me you have a new competition to be on the framework. So it may be that some of these reforms need a little bit of thinking through, but certainly the idea of having an open framework is something that's not allowed under the EU rules, and potentially a useful reform. Transparency is a theme which runs throughout the green paper. There's and it kind of crops up in different guises. There's transparency about what procurements are happening, there's transparency about what has happened, and there's also the transparency that has to be maintained through the procurement process. And there's quite extensive proposals for requirements for publishing information throughout the procurement life cycle to address concerns about lack of transparency in procurement. What the proposals don't, where the proposals are, if you like, I think probably need a little more thought, is in relation to transparency during the process and in transparency vis-a-vis bidders who challenge the process, because there's a sort of I think perhaps a sense in the green paper that by requiring authorities to disclose certain sort of types of information, that will do for the purposes of actual bids or for challenges after the event, and that's probably not the case. So I think that again, these proposals will need to be kind of worked over a bit more carefully to see that both the objective of being transparent about what's happening in procurement and the important need to be transparent during the process and afterwards are all maintained. There's some funky stuff about open contracting data and public sector bodies kind of using sort of common data standards. And there's also a suggestion for a single digital platform for supplier registration. I mean, those all seem to be quite sort of aspirational things, and it remains to be seen whether they'll be followed through. So remedies and challenges, this is a very interesting area of the Green Paper, and perhaps the area in which most substantive changes are proposed. So there is a perception that procurement challenges are too slow and too expensive, and anyone who's been involved in a procurement challenge will know that they are both slow. Well, they're very fast by most litigation standards, but by the standards of needing to get a decision so that you can award a contract, they're too slow, and they are very expensive. The Green Paper proposes a shift from essentially a sort of damages-based regime to a greater focus on pre-contractual remedies for bidders challenging decisions. In other words, the aim or the ambition is to give the challenger more of an opportunity than they currently have now to have the award decision set aside and potentially then have a retender or potentially have the contract awarded to it, rather than, as is currently the case, typically the contracting authorities are allowed ultimately by the courts to enter into contracts while litigation is going on, and then claimants pursue a damages claim. So as you'll probably know, we have had these rules for some years on automatic suspension. When a claim is issued, the authority is automatically prohibited from entering into the contract unless and until the court sets aside that or lifts that automatic suspension. And the trend almost exclusively has been that the courts have lifted the automatic suspension because they've said that, well, actually these are economic claims and damages are an adequate remedy. So whilst contract awards have been suspended for some period in the early stages of challenges, typically that suspension will be lifted and then there will be a damages claim. So the focus of the Green Paper is to move away from that regime to one where there is more opportunity for bidders to get remedies before the contract is entered into. And that raises if you're a bidder wishing to challenge a procurement, that may sound great, because what most bidders, in my experience, want is not damages, but they want another shot at the contract. And from an authority's point of view, to some extent, that's a good thing, because it means rather than having to potentially pay damages or monies in settlement, they actually get to award the contract to the right bidder. On the other hand, it does mean that challengers will have to move very quickly if the defendant authority is prevented from going ahead with the apparently successful bidder while these challenges are going on. And with the best will in the world, getting through these kind of cases in a matter of sort of a few months is very, very difficult. So there are, in addition, as it were, to the changes to the procurement rules, there is thinking going on in terms of reforms to the court rules to try and expedite even further some of these challenges. And as part of this shift from damages to pre-contractual remedies, the government proposes to cap potential damages awards very significantly to 1.5 bid costs, which is a big shift, because at the moment the rule is that effectively damages are there to compensate an unsuccessful bidder for their loss. So if they've suffered loss as a result of an erroneous procurement decision and they would have been awarded the contract, in principle they're entitled to recover the profit that they would have made on the contract. Or if they've only lost a chance to win the contract, then some estimated percentage of the profit they would have made. So that's a big change, and I kind of anticipate that there will be quite a bit of pushback on that, because it does tend to undermine, or arguably undermines, the incentive on authorities to comply with the rules, because effectively their exposure in potential damages at any rate is very, very significantly limited if that proposal is followed through. As I've said, there are proposals to streamline and speed up challenges, some discussion around whether there should be a tribunal, some sort of fast track proposals. I mean, these are all things that will be responded to and considered, but it's not clear that the government's reached any final view on those yet. Finally, on transparency, the proposal is that they remove the requirement for an award decision letter because of the sorry, I've just lost my because of the proposal, sort of the wider proposals on transparency. Again, my view is that that would be a bad step. It's important that there is a proper notification letter for unsuccessful bidders, which gives them at least the reasons for the decision and the basis on which the rationale for that decision and the basis potentially for challenging it. I think contract management is another area covered by the Green Paper. Again, this section of the Green Paper covers a range of different things. First of all, there's some further desire to tackle payment delays in the public sector supply chain. From the sort of procurement point of view, more specifically, contract amendments is a very important area, which I'm sure anyone who's been involved in procurement will be familiar with. If there's one regulation in the public contracts regulations that many people are familiar with, it's Regulation 72, dealing with contract modifications or the circumstances in which contracts may be modified lawfully without giving rise to a new contract. And the proposal, interestingly, I thought, was that no fundamental change to Regulation 72, bar some reordering and clarification of Regulation 72, which is perfectly sensible because it's fine, but it could do with some tidying up. But certainly interesting that there's no fundamental change proposed. Another important change, which I think is actually really important, is that they're proposing mandatory notices for contract amendments. So one of the discussions that we would frequently have with clients who are looking at modifying public contracts, looking at the risk assessment, is again whether you submit a VEET notice in relation to that modification, which you say is not a substantial modification, but there might be some doubt about it. And then the questions have to be raised about whether it's worth doing the VEET notice. Do you want to advertise the amendment, or do you want to rely on the limitation period expiring and all those sort of risk assessment questions that you ask? Well, the government will kind of cut through some of that and say, well, you've got to publish a notice. So there will be, if these proposals are adopted, more publicity about contract amendments, which certainly could be a good thing from a sort of national audit office, kind of encouraging compliance point of view, but from authorities' point of view and from bidders' point of view, will increase the risk. There's another sort of interesting little proposal to limit the amounts payable for contract extension where the award of a new contract is suspended due to a legal challenge. This is supposed to deal with the concern that incumbent bidders are incentivized to challenge procurement, because in so doing they delay the award of the new contract, get themselves a contract extension under their old terms or under some sort of sort of ransom strip terms, and then extract excessive profit. So whether or not that is a real concern in practice or not, I'm not sure, but certainly that is intended to try and disincentivize that kind of activity. And there's also some thoughts about using feedback to bidders more, I suppose, creatively to help improve performance going forward. That, I think, it's been slightly longer, my 30 minutes, but that is the kind of end of the overview of the Green Paper. And I will see if there are any questions. If anyone has any questions, please do, I don't know, electronically put your hand up or post a question in the questions box.
Whilst people are thinking about what their questions might be, Nick, I wonder if I can throw in one from my perspective, or a couple from my perspective actually. I think I would very much agree with your views that some of the green paper seems a little ill considered and inconsistent in some of its approaches, and there are some areas that I think are likely to sort of not see the light of day any further, but obviously there's a lot of politics with a small p, I suspect, that has gone into this. One of the questions that I had was whether, clearly, as you articulated, what government's trying to do, and I liked your expression, was trying to bank the bang that was Brexit, and the benefits of that. But do we think that this sort of proposed greater flexibility that it set out in the Green Paper is likely to deliver on the government's aspiration to see much more innovation in procurement? Is that likely to manifest itself, do you think?
Well, this is I think this is a really interesting question, because governments have struggled, whether or not they're sort of within the kind of European framework or not. The governments have always struggled to improve procurement practice. There's always been a desire to improve practice, and it's an area where there's, to my mind, there's only so far you can go, in a sense, in innovating. In lots of ways, the EU rules weren't very prescriptive in terms of how you run a procurement procedure. If you look at the fat wodge of the public contracts regulations, there's not much in there that actually tells you how to run a procurement. There are certain things you have to do. There are certain things that, notices you have to publish, periods of time you have to wait. There are obviously sort of rules about how you design your criteria and your specifications and things, but how do you actually do it? There's actually rather little in there. And, so against that background, we haven't seen sort of masses and masses of innovation. I mean, of course, there is innovation in terms of some of the sort of the financing structures and things like that, which the Treasury publishes. But, will it create lots more innovation? I think it might create a perception. I think perception is quite important. I think there's been a perception, rightly or wrongly, that the e-procurement rules are a bit of a straitjacket, where in fact I can't count the number of times I've had conversations with public sector clients and say, why are you doing that? They say, well, we have to because the procurement rules. I say, well, the procurement rules don't say you have to do that. That's just a practice, but you don't have to do it like that. And they go, oh, I see. So actually some of the perception, I think, might change without that sort of EU underpinning. But at the same time, it is, the thing which makes running procurements challenging is the requirement to maintain equal treatment and transparency. Those are the things which, make it a process which has to be followed carefully, because otherwise you end up, potentially with challenges and disputes afterwards. So I think there is scope for innovation, there is scope for change, but at the same time, I think, once the question is asked, how do we maintain equal treatment? How do we maintain transparency? You probably end up in similar places to where we are now.
And I wondered whether the change from meat to mat was one of the areas where actually you might see that inadvertently there's an opportunity for more challenge than less challenge. Do you think that's that's right, or am I being pessimistic about that?
Well, I think you are right about that, because you know, in the end, the meet criterion, or the link to the subject matter of the contract, and the sort of the strong emphasis on economics, did drive a certain way of thinking about how you evaluate, how you assess tenders, and what the criteria are. If you sort of open that up to other criteria, then you may well find people trying to challenge the criteria more than they did. Now, you may say, well, okay, there's more flexibility to have sort of non-purely economically focused criteria. Then authorities allowed to do that, and that's unlikely to be challenged. But as I said when I was doing the presentation, I think that the green paper sort of goes through some contortions on this point, because in the end, is the Treasury going to sign off on a set of procurement rules which really encourage contracting or public bodies around the country to do things which aren't necessarily best value for money? I think that's quite unlikely. So I suspect that these kind of flexibilities might be quite kind of cautiously approached, and with a sort of perhaps some more caution than is being presented in some of the sort of the opening stuff, for example, in the green paper. You might find authorities find it quite difficult to tell what are we supposed to take into account. Are we supposed to make this purely economic? Are we supposed to take into account some other so those questions become quite difficult. So it could lead to both to more sort of challenging kind of exercises in designing procurements, but also it could well lead to more challenges, I think.
So, reading some of the questions that is had in the box, how well do you consider that courts are likely to be able to deal with the potential shift from the damages regime when they're looking at challenge? And I think that's a good question. I think the area around remedies and challenges, you say, has got lots of bits in it that are likely to upset people a bit.
Yeah,
so.
I think it's a really tricky one, because as I was saying, I think the move to pre-contractual remedies ought to be welcomed, but it really is dependent on being able to get these cases dealt with swiftly, and not just swiftly, also rigorously. So if the trade-off is between swiftness and rigor, I'm not sure it's a good thing to have sort of less rigorous processes. And certainly there are elements to the court process that could be made simpler and improved. There are sort of incremental changes that can be made. I mean, there are proposals, for example, to sort of introduce some form of fast track process for smaller claims. But if you're thinking about, big contracts and big claims, with the best will in the world, it's difficult to do a rigorous process with a disclosure that's involved in a very rapid period of time. And if the objective is that the contract award is effectively suspended for that period of time, then that's going to delay new contracts being entered into. So there is quite a tension, I think, between the proposal to refocus on pre-contractual remedies and the desire to do everything kind of swiftly and flexibly and so on and so forth. So I think there are important questions that need to be sort of much more thought through in much more detail than is currently in the green paper.
We've had a question about frameworks. So looking at frameworks, this appears to be 4 years. This doesn't align with current client control periods, as these tend to be 5. What's your view on this? How do you see the opening up for new entrants?
Well, I mean, frameworks currently, the current rules say that maximum duration of a framework is 5 years. sorry, it's 4 years, except in exceptional circumstances. So you can have a longer framework if there's a good reason to have a longer framework. But normally the normal duration is 4 years, and that's been the case for some time. As far as opening up frameworks is concerned, this sort of proposal to have an open framework, as I was saying, I find this, again, you know, the desire for greater flexibility kind of hits up against the principles of equal treatment, because what they say in relation to the open frameworks is, well, you can let's say you have it closed for 3 years, and then you open it up after 3 years to new suppliers. Fine, you open it up. A new supplier can bid to join against the same criteria that we used when the framework was set up. But they also say that the existing suppliers should also have a chance to rebid, because otherwise they could be disadvantaged, because if there's been some improvement or change or lower costs, then some new supplier could come in with a more competitive offer and stand a better chance of winning work on the framework. So what you effectively have is a retendering of the framework at that point, because anyone can join, including the existing suppliers who may wish to rejoin, as it were. So again, I think, you know, that makes sense in terms of treating everybody equally and giving everybody a fair chance. But it does also mean that, you know, if you like, the procedural benefits of having an open framework are perhaps not as obvious as they may first appear.
One final question, perhaps a little loaded, or I'm going to make it a little loaded in some ways. Do you think that the paper deals adequately with support which contracting authorities who, you know, in fairness, are not necessarily dealing with large procurements all the time, and therefore, you know, are not necessarily equipped to deal with these procurements, and do need support, I think, in a way in which they haven't necessarily benefited from hitherto. Do you think the proposals are enough? Do you think that actually more needs to be done to support contracting authorities?
Yeah, I mean, that's one of the feelings I had when I was reading the Green Paper, was that it's quite kind of central government oriented. You know, there's the idea of kind of improving commercial capability, and it sort of read like something which was sort of there for, you know, the had in mind the sort of civil servants running big projects. I mean, that may be unfair, but I mean, that seemed to me to be sort of quite a lot of the theme. Whereas I think absolutely of lots of smaller authorities, not just local authorities, but also sort of smaller, particularly smaller sort of NDPBs and other public bodies, much smaller scale than local authorities. You know, they don't really have much in the way of often procurement capability. They have some, but some of this stuff could be quite challenging for some smaller bodies to deal with, and you know, it will, I think, need some support. I mean, there is this idea that greater support will be provided. So there's this new oversight panel. If that's set up in a way which is not, you know, overly judgmental, which I think is the intention, whether that'll be the reality, I don't know, but the intention is it's not overly judgmental. But yes, I mean, I think that it would take quite a lot of effort on the part of, you know, the procurement, those who are steeped in procurement practice in the Cabinet Office, to filter, you know, these kind of good new practices down to the sort of full range of public sector bodies beyond, you know, central government departments and, you know, larger local authorities. So it's a really good question, actually. I do think there's quite a bit in the Green Paper which is quite, some of the stuff about open data standards and some of the stuff about general transparency is fine, but it will create a greater administrative burden, which will fall heavily on smaller bodies.
I realise I've missed a question, which I think is I think lots of the people on the call will want to have some view on this, so I'm going to squeeze it in if I may. And it is about the age-old question about inward investment into property schemes. So the question is framed: do we see any clarity on whether procurement will apply in certain situations or not? At the moment, inward investment into property schemes can be considered worthy of an OJU, or FAT, I guess now, by some local authorities and not by others. So I guess the question is there has anything in the green paper gonna give a bit more?
No.
No.
The answer.
Yeah,
no is the answer. I mean, it is an interesting point, because I think that whole question, which Cecily, you and I have talked about and many times, about whether this or that scheme gives rise to a public works contract. It's a constant thorn in the side of these projects, and it's all driven by European case law. And in fact, when I was mentioning European, the sort of domestication of EU case law, the Rowan or the Oru case that everyone knows in that area is another well-known name, and all that case law then gets sort of translated into domestic law, so it's all still there. Obviously have domestic interpretations of that case law. The Faraday case recently was very well known on development schemes. So all that remains. What changes is that the courts will have some greater ability to depart from the EU cases. So courts above the Court of Appeal and above will have some ability to depart from those cases. So there will be opportunities in specific claims to argue that actually this is no longer really appropriate, however, and for the law to develop. But that's not something that the government is looking to legislate for in the Green Paper.
Thanks, Nick. I'm conscious of time. Thank you very much, does. Conscious of time. I think maybe by way of wrap up, the only thing that I would rehearse is that the consultation period comes to an end on the 10th, as we've said. I anticipate that government will publish some of the responses that it has, and there will continue to be dialogue on this. So we will no doubt speak to you all again on this, and if there are any further questions that arise from what you've heard today or from what you've read in the Green Paper, then do please come back to us. Thanks very much for joining, and hope to see you all again soon.
Thanks very much for joining, everyone.